Hi, it's me, Mary Jean Ziska again. It is now 5 o'clock p.m. It is the 19th of May, 2015, which is Tuesday, and it is, oh wow, it's 91 degrees in here. No wonder I'm hot. Anyway, I'm doing this video today for a few points, and I'll be uploading all of the information. But basically, I want to talk today about bankruptcy fraud, identity theft, the problems with guardianships and limited guardianships, and the problems I'm having removing a fraudulent bankruptcy. So basically, I wanted to first go into the problems with limited guardian. According to the Florida Statute 744, guardianship can be divided into different types of guardianship. A limited guardianship, which I have, is actually only supposed to cover two areas. They're supposed to help defend lawsuits, and they're supposed to actually help to contract. So far, by having this limited guardianship, started in 2006-2007 with Patrick Weber. He was supposed to help actually stop David J. Stern, his fraud. He's was a lawyer who actually was indicted in racketeering, who actually has been disbarred due to his theft, his crimes, and his fraud, mortgage fraud. He got a hold of my information and kept trying to sell my mortgage. First he tried to foreclose upon it. Matthew Kale, which, surprising enough, it's the same last name, or sounds like the same last name as a girl who bullied me, was listed as trying to actually forge a assignment of mortgage. They didn't have any right to my mortgage, and in the process tried to foreclose upon my house. Weren't allowed to, and from that point on, all hell broke loose, including the second identity theft and all types of problems. Anyway, this limited guardianship is only supposed to help with two different sections, and right now it's actually supposed to be helping with defending lawsuits and which would be a foreclosure, but I don't have any foreclosures. I actually had a Linda Yeager who threatened that there was a foreclosure pending. There wasn't, but I'll get into that later. So I wanted to read you the document. This this actual identity theft led to someone actually creating a false mortgage through Ocwen. They were able to take off $65,000. And I think they got a condo somewhere from money that they stole. $65,000 went to a new car, to new appliances, and to classes, which I didn't obtain any of those finances and wasn't able to actually reap any of the rewards. This was all the criminals. Also, the ID theft, because of that, there was people who wanted me to claim bankruptcy to actually hide the $65,000 that they stole, to cover up the mortgage fraud that they created, and pretty much to screw up my credit. And I think their end result was to try to steal my condo. Supposedly in the guardianships, there's been different people who've done this to elderly people. I'm only 48 years old, so I am fighting like heck to try to stop everything these criminals are doing. Anyway, this is a bankruptcy. Linda Yeager did remove a Chapter 13 bankruptcy, and then a Chapter 7 bankruptcy showed up on my credit report, which is a fraudulent bankruptcy. I'm trying to remove that. Nobody's listening and nobody's helping, so I thought putting this YouTube video might actually help to, to stop it, I guess. Anyway, I filed a complaint against the Better Business Bureau. I've actually filed all kinds of different documents and emails and sent them to actually stop this fraudulent bankruptcy and to have it removed from my credit report and from my public records. Now, fraudulent Chapter 7 bankruptcy, the bankruptcy was issued and established in Tampa, Florida. The date it was filed was 7/11/2014. Means it's July 7th, 2014. The reference number 1408053 CED. It's listed on my credit report and needs to be removed. Chapter 13 had been appearing on my credit report prior to this Chapter 7 and has already been removed by Linda Yeager, Y-E-R-G-E-R. She's a lawyer here in Naples, Florida. She assisted in removing the Chapter 13 once the proper authorities, the Department of Justice, the Fraud Department in both Washington and Tampa, were alerted to the fraud, criminal activity, and corruption involved. I received an apology email in October of 2014 from Linda Yeager, Y-E-R-G-E-R, confirming the removal of the bankruptcy off my credit report. However, now a Chapter 7 is appearing on my credit report that is just as fraudulent and needs to be removed. As per the Bankruptcy Code of Florida, multiple infractions demand a removal of this fraudulent bankruptcy. These 10 infractions of the law create this fraudulent bankruptcy and are listed below. This is a document I created to actually send to all the different people who need to know that there's a fraudulent bankruptcy, that someone dropped the ball and allowed a fraudulent bankruptcy to actually go through to cover up theft. Number one, lies of my mental capacity and age. I am Mary Jean Ziska. I have never given in writing nor in a verbal agreement that I agreed to the filing of either a Chapter 13 or a Chapter 7 bankruptcy. I am a 48-year-old woman, not under the age of 18, or involved in a full-fledged guardianship determined by the court system for a minor child. I am also not incapacitated and I am not incompetent. I presently had, in 2014, a limited guardian who was supposed to assist only with 2 separate areas. 1, to defend defensive lawsuits, and 2, the ability to assist in contracts. As per filing the Chapter 13 or Chapter 7 bankruptcy, Patrick Weber was the limited guardian in July of 2014. Larry Pevicek was the guardianship lawyer in July of 2014. Neither of these men were ever consulted about the bankruptcy being created, nor did they authorize in writing the authority for anyone, including Linda Yeager or Marion Gregory, to start, file, or complete any form of bankruptcy using my name, my address, or my personal information. Then I have a star and an asterisk, and I have this under every point. These actions were and still are in violation of the Bankruptcy Code and grounds for dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and on my credit reports. Number 2, as per violating the legal rules for filing a bankruptcy, that I found those legal rules under www.uscourts.gov. In quotes, bankruptcy begins when a debtor files a petition with the bankruptcy court. A petition may be filed as an individual, a spouse together, or by a corporation. According to this rule contained within the Bankruptcy Code, neither Linda Yeager nor Marion Gregory fits the criteria for even filing a Chapter 13 or Chapter 7 bankruptcy using my name, my address, or any of my personal information and individual identifying information. Neither Marion Gregory nor Linda Yeager filed as an individual, meaning the person and individual of Mary Jean Ziska, or filed as my spouse, or filed in the name of a corporation. A stranger or unauthorized person is not allowed to file a bankruptcy using my name, my address, or any of my individual and personal identifying information. I am stating in writing that I, Mary Jean Ziska, I have never met with Linda Yeager, never hired Linda Yeager to file a bankruptcy, and never given Linda Yeager any financial compensation to perform any legal services for me, which means that I would have never contracted her services. I have never seen, been sent, or discussed any completed legal documents created or filed by Marion Gregory or Linda Yeager concerning these fraudulent bankruptcies. In fact, I received an email from Linda Yeager apologizing for the harm she did to my life and to my credit. In the email she mentioned, and I quote, "She was just trying to help," end quote. And within the email, she guaranteed that the Chapter 13, the only bankruptcy appearing on my credit report in October 2014, would be dismissed and removed from my credit reports. This email was sent to me Tuesday, October 7th, 2014 at 1:29 p.m. The Chapter 13 bankruptcy was removed from my credit report, and then Chapter 7 appeared after the Chapter 13 was off my credit report. Linda Yeager and Marion Gregory were not authorized through the court system nor given my personal permission to file any bankruptcy, whether it was Chapter 13 or Chapter 7, using my information. I definitely did not give my permission nor want any bankruptcy in my life, especially when filing this paperwork would ruin my credit for 10 years, created an additional cover-up of the mortgage fraud and identity theft from 2012, and also covered up a theft of finances. The $65,000 I mentioned earlier, used by criminals to purchase a new car, new appliances, and to take classes. In fact, once I learned of the incorrect information and lies Linda Yeager and Marion Gregory used in their bankruptcy filings, I protested by contacting the proper authorities, both by phone and email, the Department of Justice in Washington and Tampa, the bankruptcy fraud departments, the Stop Fraud and government websites, and also contacting the Florida Bar, the ACAP, for filing a complaint. In September 2014, I began speaking with Heidi B., I don't have her last name, to file a formal complaint with ACAP against Linda Yeager and these illegal practices. The lies and incorrect information Linda Yeager based her Chapter 13 and Chapter 7 bankruptcy filings violated the Bankruptcy Code of the United States of America, here in Florida, the Ethics Code for Lawyers established by the Florida Bar, violated both local and federal, including violation of the personal civil rights of a disabled individual and abuse and misuse of authority designated by a limited guardian. Point 1. Mortgage debt and personal debt. Under Section A, lies about mortgage debt that were pertaining to lies made about me. Linda Yeager lied about a $500,000 mortgage debt based on the identity theft and mortgage fraud of a fraudulent ocwen mortgage, where in addition to a fraudulent mortgage, there was $65,000 taken and used to purchase a new car, new appliances, and were used for classes, as per the 3 credit bureaus. I filed police reports concerning the fraudulent items on my credit report, including the fraudulent mortgage that was created from another mortgage fraud, the one I mentioned earlier, David J. Stern, and identity theft in 2006-2007 by David J. Stern. Ocwen loan servicing item 81003XXX was deleted from my credit report after my dispute on August 19, 2014. The file number for that dispute was 32547979. B. Lies about my personal debt. I have no personal debt. I own my own car without any debt, 2004 Saturn. I have no mortgage on my home as of 2004-2005. My condo has no legitimate mortgage associated with it since 2004-2005 before David J. Stern, and his criminal activity necessitated the need to have the assistance of Patrick Weber as a limited guardian to help defend lawsuits. David J. Stern attempted to foreclose upon my condo with no legitimate assignment of mortgage, which was common for him, resulting in the loss of his ability to practice law in 2014. I went to college at the University of Florida and paid off any college loans in full after graduating with my bachelor's. I have no credit cards, therefore no credit card debt. I have no loans, therefore no loan debt. I especially have no debt for a new car, new appliances, or for additional classes. Instead, as of July 2014, I had a 728 credit score for Experian, Equifax, and TransUnion, and no personal debt. The lies about foreclosure. Point C. Linda Yeager and Marion Gregory lied about foreclosures which were never filed, using scare tactics and bullying to achieve their desired outcome of fear, manipulation, and control. I contacted the Naples Clerk of Courts in 2014 when these allegations of foreclosure were being made by Linda Yeager and Marion Gregory. Neither in 2014 nor most recently, I actually called them again on May 12, 2015, were any foreclosures filed in my name or on my condo. I went online to check records and spoke with the clerks who verified the same findings. If any foreclosures had been filed, Patrick Weber was enlisted by the courts to assist in my defense, not Linda Yeager for filing bankruptcy. Point D. Lies about HOA debt. allegations of $100,000, $100,000 debt for my HOA. Tom Frazier was hired in 2013 to mediate through any HOA debt that had occurred during the time frame that Patrick Weber was enlisted to assist as a limited guardian. According to Tom Frazier, when he came over to my home for lunch in 2013, there remained only a $10,000 debt to be paid to the Homeowners Association. Linda Yeager's allegations of $100,000 debt remaining in 2014-2015 from the Condo Association was grievous miscalculation when only $10,000 were owed to the Strand Association and listed as a lien in the court documents. I would not file bankruptcy for a $10,000 debt, especially when I had no personal debt, no mortgage debt in my life, or on my credit. In fact, after I had cleared off the last items of identity theft, I had contacted my bank, where I have done banking for the past 7 years, to review my accounts and inquire about an equity line of credit to pay this bill and to do minor repairs and improvements to my condo. Now these actions, I put a little star by it, these actions again are in violation of the Bankruptcy Code and grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and my credit reports. In fact, it actually violates, if you look at the Florida Bar, as far as the ethics, it violates quite a few of the different grounds for ethics. The expectations of a lawyer. A lawyer should not enter into a lawyer-client relationship with the lawyer when the lawyer cannot provide competent and diligent service to the client through the cause of representation. A lawyer, that's 1.4 of the expectations. A lawyer must place a client's best intentions ahead of the lawyer's or another party's interest. That also, because Mary and Gregory or someone else was actually, their interests were above mine, that was also a violation, 1.7 of the expectations. 1.11. A lawyer must routinely keep clients informed and attempt to resolve clients' concerns. In the case of irreconcilable disagreements with the client, the lawyer must provide diligent representation until the lawyer-client relationship is finally dissolved in compliance with the law and the client's best interest. Point 2.9. A lawyer should not withhold information from a client to serve the lawyer's or the lawyer's own best interest. Point 2.10. A lawyer must not knowingly mistake, misrepresent, or distort any fact or legal authority to the court or the opposing counsel and must not mislead by inaction or silence. Further, the discovery of additional evidence or unintentional misrepresentation must immediately be disclosed or otherwise corrected. Point 3. Adherence to a fundamental sense of honor, integrity, and fair play. Courtesy, cooperation, integrity, fair play, and abiding by a sense of honor are paramount for preserving the integrity of the poly system and ensure the fair, efficient, and effective administration of justice for the public. Sorry, my handwriting's a little sloppy. I was trying to read it. Professionalism expectations. Professionalism is the pursuit and practice of the highest ideals and tenets of the legal profession. It erases from more than simply complying with the minimal standards of professional conduct. The essential something, I should have written it in print, of professionals are character, competence, commitment, and civility. That's a quote from the Florida Bar. I'll try to actually improve on that. Anyway, point number 3. As per violating the legal rules for filing a bankruptcy according to the www.uscourts.gov. This is another quote, Chapter 7, 11 U.S.C. 707B. as per the U.S. Bankruptcy Code. Moreover, the courts may dismiss a Chapter 7 case filed by an individual whose debts are primarily consumer-related rather than business debts, if the court finds the guarantee of relief would be an abuse of Chapter 7. This fraudulent Chapter 7 bankruptcy was originally filed as a fraudulent Chapter 13 bankruptcy, not based on business debts nor individual debts, but based on a mortgage fraud debt. And again, these actions were and still are in violation of the Bankruptcy Code and grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and my credit reports. Point number 4. As per violating the legal rules for filing a bankruptcy, www.uscourts.gov. Quote, an individual cannot file under Chapter 7 or any other chapter if there was a willful failure to appear before the court or comply with orders of the court. I, Mary Jean Ziska, did not attend any meetings, including the 341 meeting, with the trustees concerning the filing of these fraudulent bankruptcies. I, Mary Jean Ziska, did not attend these meetings on purpose, and as a willful failure for not attending these meetings, intended for the bankruptcy proceedings to be stopped, when nothing I did or said was stopping the unauthorized filing of these bankruptcies. I did not meet with Linda Yeager in any meetings. In fact, I have never met with Linda Yeager at all. In addition to trying to stop these fraudulent bankruptcy proceedings and to stop the bullying and harassment, I tried to file a restraining order to stop Marion Gregory and Antonella Scarpa from trespassing onto my property or bullying me any further in my own home. I would not and did not hand over my driver's license nor any Social Security card to Marion Gregory. I was bullied at 11:30 p.m. with the sheriff present to force me to sign one blank document that had no personal information pertaining to me on either a Chapter 13 or Chapter 7 bankruptcy. I have no knowledge on how that signature was used and abused, as I was never consulted nor shown any completed legal official documents with my signature. I was bullied into turning over banking statements to Marion Gregory and Antonella Scarpa when they trespassed onto my property, and I regret failing to be strong enough to stand up to being bullied. After their final abuse, I filed financial exploitation abuse reports with Adult Protective Services, attempted to file a restraining order, and filed police reports with the Social Security and police concerning the bullying, the money stolen, $1,222.99, and the fraudulent bank account they opened at Fifth Third Bank using my name, my Social Security number, and all my personal information. These individuals lied to Fifth Third Bank, lied to the courts, lied to the Social Security office, lied to judges, and lied to the bankruptcy officials to achieve their own desired goals. Excuse me. Their actions have harmed my life, my credit, and my finances. Their actions were never requested by me, and that is specifically why I willfully did not attend any meetings to complete any type of bankruptcy. These actions were and still are in violation of the Bankruptcy Code and immediate grounds for dismissal and removal of the Chapter 7 bankruptcy for me, Mary Jean Ziska, on my public records and on my credit reports. Point number 5. As per violating the legal rules for filing a bankruptcy, as per the www.uscourts.gov. In addition, no individual may be a debtor under Chapter 7 or any other of the Bankruptcy Code unless he/she, within 180 days before filing, received credit counseling from an appointed credit counseling agency with an individual or group briefing. That's according to 11 U.S.C. 109,111. There are exceptions in emergency situations where the U.S. trustee or banking administration has determined that there are sufficient grounds, approved agencies to provide the required counseling. If a debt management plan is developed during the required credit counseling, it must be filed by the courts. I, Mary Jean Ziska, did not attend any credit counseling sessions at any point in time, let alone within the 180 days required by the Bankruptcy Code before filing for any type of bankruptcy. I was never consulted about classes or any debt management plan. No debt management plan was ever developed or filed at the courthouse on my behalf. These actions were and still are in violation of the Bankruptcy Code and grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and my credit report. Point number 6. As per violating the legal rules for filing a bankruptcy, www.uscourts.gov. During the meeting, the trustee puts the debtor under oath, and both the trustee and creditors may ask questions. The debtor must attend the meeting and answer questions regarding the debtor's financial affairs and property, as per 11 U.S.C. 343. I, Mary Jean Ziska, never attended the meeting with the trustees. I, Mary Jean Ziska, never took an oath before the creditors or trustees. I, Mary Jean Ziska, did not answer any questions about my property or my financial affairs to the trustees or creditors. These actions were and still are in violation of the Bankruptcy Code and grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for me, Mary Jean Ziska, on my public records and my credit reports. Point number 7. As per violating the legal rules for filing a bankruptcy, as per www.uscourts.gov. Within the 10 days of the creditor meeting, the U.S. trustee will report to the court whether the case should be presumed to be an abuse under the means test discipline in 1 U.S.C. 704. I have no knowledge if any actual paperwork is ever filed, but these actions were and still are in violation of the Bankruptcy Code. It should have been found out immediately that there was abuse being taken on, that it was a bankruptcy fraud, and it should have been dismissed immediately, as the Chapter 13 had been dismissed and removed from my credit report. So these actions were and still are in violation of the Bankruptcy Code and grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for me, Mary Jean Ziska, on my public records and my credit report. Point 8. As per violating the legal rules for filing a bankruptcy, as per www.uscourts.gov. Quote, in order to accord the debtor complete relief, the Bankruptcy Code allows the debtors to convert a Chapter 7 case to a case under Chapter 11, 12, or 13. And it's in parentheses the number 6, as long as the debtor is eligible to be a debtor under the new chapter. However, a condition of the debtor's voluntary conversion is that the case has not previously been converted to Chapter 7 from another Chapter 11 USC 706.A, from another chapter. And then that's actually a quote from 11 USC 706A. Thus, the debtor will not be permitted to convert the case repeatedly from one chapter to another. This is a clear violation of the Bankruptcy Code, and just this one point alone should have had it removed immediately. The dates are the same, the number is the same. It was converted from a Chapter 13 to a Chapter 7, is what it appears to be. Linda Yeager and Marion Gregory first filed a Chapter 13 in July of 2014, and when confronted with all the fraud and infractions of the law and Bankruptcy Code, Linda had that dismissed and removed from my credit report. It appears that when the Chapter 13 was removed, it was then converted into a Chapter 7 bankruptcy with the same date, July 2014, and the reference number 1408053 CED, I don't know what that means. The Chapter 13 was removed because it was based on a mortgage fraud and identity theft from 2012. The multiple errors that were found in the fraudulent filing of the Chapter 13 bankruptcy are and were still prevalent in the Chapter 7 filing, including even more grievous infractions. As per the Bankruptcy Code, converting a Chapter 7 from a Chapter 13 is a clear violation of the Bankruptcy Code, and it in itself grounds for dismissal and removal of this fraudulent Chapter 7 item from my public records and my credit report. These actions were and still are in violation of the Bankruptcy Code and grounds for the immediate dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and my credit report. Point 9. As per violating the legal rules for filing a bankruptcy, as per www.uscourts.gov. Quote, as to a reformation agreement, reaffirmation agreement and personal liability for debt. End quote. End quote again. If the debtor was represented by an attorney in connection with the reaffirmation agreement, the attorney must certify in writing that he or she has advised the debtor of the legal effect and consequences of the agreement, including a default under the agreement. The attorney must also certify that the debtor was fully informed and voluntarily made the agreement, and that the reaffirmation of the debt will not create an undue hardship for the debtor or the debtor's dependents. I am unaware of any reaffirmation agreement made by Linda Yeager and Marion Gregory, but I certify that myself, Mary Jean Ziska, I was not consulted. I never agreed to any part of the Chapter 13 or Chapter 7 bankruptcy filed by Linda Yeager and Marion Gregory. I was never informed of the consequences of any such agreement. I did not make any voluntary agreement. This agreement for this Chapter 13 and Chapter 7 bankruptcy have done nothing but cause undue hardship in my life. Since July of 2014, this bankruptcy by Marion Gregory and Linda Yeager and Antonella Scarpa has done nothing but cause undue hardship to my life. These are the points of hardship that it has already caused. Point 1. I've been bullied and harassed when I did not want to go. I did not want and would not sign paperwork to turn over my Social Security card or my driver's license. I even had the police called to my condo to try to force me to sign paperwork when I did not want to file any type of bankruptcy. Point 2. I was lied about, that I was suicidal, then incompetent, then incapacitated, and involuntarily and forcibly Baker acted in October of 2014 on my way home from the grocery store when I would not complete any paperwork for the bankruptcy, would not hand over my personal identifying information for the bankruptcy, when I started to file a complaint with the Florida Bar concerning misconduct, ACAP Division, September 2014, and when I sent emails reporting the bankruptcy fraud to the Department of Justice in both Washington and Tampa. Point 3. I have had money stolen from my Social Security direct deposit, $1,222.99, for January, February, and March of 2015 that has still not been returned. When these finances were stolen, I was left in March 2015 with only $100 to survive the month and the deductions on my food stamps that still has not been repaired. I have had fraudulent bank accounts at Fifth Third Bank opened in my name using my Social Security number, my address, to continue the theft and the fraud. Started in 2012, covered up by this fraudulent bankruptcy, and actually continued. Point number 4. I have had money stolen from my food stamps March, April, and May of 2015 and went without many items to eat while fighting the theft of funds, the fraudulent bankruptcy, and all of this criminal activity. Point number 5. I have had to file legal documents and paperwork enlisting assistants and lawyers and legal companies to try to rectify these horrid crimes against me. Paperwork documents included petition to compel, police reports for theft of money and ID and fraud, reports to Social Security office, reports to banks, ID theft paperwork to all these credit bureaus. I have had to file Adult Protective Service abuse reports to stop the continued harassment and abuse. I even attempted to file a restraining order to stop the abuse, harm this has caused in my life. I have been denied credit from my bank, and the equity line of credit was not put through because of the damage of the filings of these fraudulent bankruptcies have had on my credit reports. The entire situation has compromised all of my direct deposits, bill payments, and almost cost me my bank account that I've had in good standing for the past 7 years. I had to sell an old roommate's bike, old golf clubs, and not be able to tithe the month of March for 2015 just to make ends meet. I've had to use unnecessary expenses, time, and even travel to try to locate additional legal defense assistance to protect me from the people who are hurting me. Point number 9. I've had to use what little finances I had to create duplicates of documents and distribute those to people who I hoped would help to stop the fraud and the abuse. Point 10. I've had to hire multiple additional companies to continue the disputes with the credit bureaus. I've had to complete numerous online and phone disputes dealing directly with Experian, Equifax, TransUnion, and LifeLock and my bank just to try to stop the injustice and remove these fraudulent bankruptcies. These actions were and still are in violation of the Bankruptcy Code, grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for me, Mary Jean Ziska, on my public records and on my credit reports. Point number 10. As per violating the legal rules for filing a bankruptcy. As per www.uscourts.gov. This is in quotes. 11 U.S.C. 727. The court may revoke Chapter 7 discharge on the request of the trustee, a creditor, or the U.S. trustee if the discharge was obtained through fraud by the debtor, makes a material misstatement of or fails to provide documents or other information in connection with the debtor's case. These entire bankruptcy filings have been full of fraud. I have been demanding and filing disputes with the credit reporting agencies, with the Department of Justice, fraud agencies, with the bankruptcy trustee agencies in both Washington and Tampa. I have reported this fraud to lawyers, to credit bureaus, to agencies, and to every government agency who will listen. I have attempted to contact any and every proper agency with the authority to stop the bankruptcies, and when they were not stopped, to remove them from my life. I have filed and sent emails to dispute the information to the Department of Justice, to the Better Business Bureau, to the Attorney General, to LifeLock, and all the credit assisting companies, Experian, TransUnion, and Equifax. I have done everything in my power to stop and remove this fraud since its inception in July of 2014. In conclusion, all these violations of the Bankruptcy Code are grounds for immediate dismissal and removal of the Chapter 7 bankruptcy for Mary Jean Ziska on my public records and my credit reports. I demand that the fraudulently filed and fraudulently executed Chapter 7 bankruptcy, date filed July 2014, reference number 1408053 CED, be dismissed and removed from my public records, from my credit report, and from the legal system. Thank you for your kind attention to this email, to this video, that actually I hope you will see how much damage that this fraudulent bankruptcy has done to my life, and please do anything in your power to remove it. Thank you, take care, and God bless. Today is May 19th, 2015, and it is 5:37 p.m. Bye. Oh, I should show you my driver's license. Prove who I am. Hold on. Hopefully you can see this. Bye.